So what happens when a simple disagreement with your homeowners association, well, isn't so simple? What if it doesn't just end with a warning letter, but actually explodes into a full-blown legal battle? That's what we're digging into today. This is a real story about some pretty big money, very precise rules, and the incredible power of the fine print.
Look, if you've ever lived in a community with an HOA, chances are you've butted heads at least once, right? Maybe it was about how tall your grass was, or the color you painted your front door, or some surprise fee you didn't see coming. Well, this story takes that everyday friction and just cranks it all the way up to a courtroom battle.
So, let's meet the players. On one side, we've got the petitioner, a resident named Kenneth Nowell, and on the other side, we have the defendant, the board of the Greenfield Village RV Resort Association. It's really that classic showdown, the individual resident versus the institution.
So how in the world does a disagreement over community management get this serious? To really understand what this fight was all about, we've got to understand the setting.
Okay, so picture this, an RV resort down in Mesa, Arizona. You're probably imagining a pretty peaceful place, right? A community designed for a quiet, leisurely kind of lifestyle? But, as it turns out, just beneath the surface, a serious conflict was brewing.
Now, at the absolute heart of this case, and really any HOA dispute, are the governing documents. You can think of these as the community's constitution. You've got the CC&Rs, the bylaws, and the articles of incorporation. Every single argument, every decision, it all comes back to what's written down in these pages.
Mr. Nowell didn't just have some vague complaint. No, he filed a formal petition, and it had 3 very specific allegations against the board. So let's break down exactly what he claimed they did wrong.
His entire case really rested on these 3 pillars. First, a massive land purchase that he believed was totally illegal. Second, a pretty questionable payment that was made to secure that land. And third, the construction of a new beverage center that he felt lacked proper approval. We're going to tackle these one by one. All right, first up is the big one, the land purchase. This was, without a doubt, the most significant financial decision at the core of this whole dispute.
The board spent, get this, a staggering $940,000 to buy a piece of land right next to the resort. I mean, for the residents, this was a huge expenditure, and Mr. Nowell was convinced it was a massive overstep of the board's authority.
Now, Mr. Nowell's argument here was basically twofold. First, he claimed that the governing documents, those CC&Rs, simply did not give the association the authority to go out and buy property. And second, he argued that even if they could, they funded it the wrong way, by hitting the residents with an improper special assessment.
Okay, let's move on to the second allegation. This one involves a very, very precise amount of money, and honestly, it's a fantastic lesson in the importance of reading the fine print.
So before that big $900,000 purchase, the board paid exactly $20,000 from their operating funds just to secure an option on the land. Mr. Nowell's argument was that an expenditure of this size absolutely required a full vote from all the association members, a vote that never happened.
And finally, we have the beverage center. Now, this one might seem a little smaller than a $1 million land deal, but it touches on a really key part of HOA life, making changes to the shared spaces everyone uses. The board went ahead and authorized the construction of a new, bigger beverage center, which cost $79,000. And the money for it came from a few different places, some donations, some operating funds, and also from the community's long-range reserve fund. Mr. Nowell's position on this was crystal clear. For him, this wasn't just some simple repair or a minor upgrade. He argued that it was a significant alteration to the common area, that it actually changed its nature. And according to the rules, a change like that needed approval from the entire membership, not just a thumbs up from the board. So there you have it, the 3 big allegations. The case goes before an administrative law judge, and after all the arguments, what was the final decision? Let's get to the verdict.
The outcome? Wow. It was a clean sweep. On all 3 counts, the judge sided with the HOA. The land purchase, totally legal, according to the Articles of Incorporation. The beverage center, the resident couldn't prove it was a fundamental change. But the most fascinating ruling, the one that really shows you the power of fine print, was about that $20,000 option.
And here it is. This is the exact detail that decided the whole issue. The community bylaws stated that a vote was required for any capital expenditure in excess of $20,000. Those 3 little words, in excess of, they meant everything.
See, the board spent exactly $20,000. Not 20,001 cent, just 20,000, flat. And since that amount was not in excess of $20,000, no vote was technically required. They followed the letter of the law perfectly.
So why? Why did the resident lose on every single point? Well, it all boils down to a fundamental principle of our legal system.
And that principle is called the burden of proof. You see, in a case like this, the person who's making the accusation, in this case, Mr. Nowell, has the responsibility, the obligation to provide enough convincing evidence to prove their claims. It's on you to actually tip the scales of justice in your favor.
And you know, the judge's own words from that final decision really say it all. He wrote that Mr. Nowell simply did not present enough evidence to show that the board had actually broken the rules as they were written. His interpretations of the rules just weren't enough to meet that burden of proof.
And so that was it. The petition was dismissed. The court officially declared the HOA the winner of the dispute. It was a complete and total victory for the board. This whole case really boils down to one critical question for any resident living in an HOA. If you're going to challenge your board, it's not enough to just feel like you're in the right. You have to be able to prove it based on the exact wording of the rules. So the real question is, do you know those rules as well as your board does? Because as this case proves, the devil is always in the details.